You're listening to the Bare Metal Cyber Prepcast, created to help you succeed in your educational journey. Learn more at baremetalcyber.com, where additional prepcasts, books, and training materials await. Let's get started. The Right to Financial Privacy Act, or RFPA, was passed in 1978 after the Supreme Court ruled that individuals had no reasonable expectation of privacy in bank records held by financial institutions. Congress responded by giving bank customers statutory rights that limit how federal agencies can access their financial information. The law ensures that customers are notified when federal authorities seek their records and, in many cases, gives them the chance to challenge requests before disclosure occurs. For learners, this demonstrates the way statutory privacy rights can fill gaps left by judicial interpretations. The RFPA places financial institutions in the role of custodians who must protect records until proper legal process is followed, creating a buffer between government investigators and the personal financial information of ordinary citizens. The RFPA applies to a wide range of covered institutions, including commercial banks, savings associations, and credit unions, as well as credit card issuers and some mortgage providers. The term customer is also defined carefully, focusing on individuals and partnerships of 5 or fewer people, but not extending to larger corporations. This focus reflects Congress's intent to protect individuals and small businesses rather than shielding major enterprises from oversight. For learners, this scope shows how privacy protections often distinguish between different categories of entities. Just as medical privacy laws treat patients as the primary focus, financial privacy statutes prioritize individual customers whose banking data may reveal intimate details about their lives, spending habits, and associations. Central to the RFPA is the customer notice requirement. Except in specific circumstances, federal agencies must provide customers with a copy of the request for their records and allow them an opportunity to challenge it in court before disclosure occurs. This notice empowers individuals to assert their rights, preventing one-sided government access. For learners, this requirement demonstrates how privacy protections translate into procedural fairness. Without notice, individuals would never know their data was being scrutinized. With notice, they gain the ability to question relevance, scope, or lawfulness, even if courts ultimately decide disclosure is justified. The right to contest ensures that privacy is not eroded silently, but weighed transparently in the legal process. The RFPA outlines multiple legal pathways for obtaining records, each with different procedural safeguards. Agencies may use a formal written request that requires certification of relevance, an administrative subpoena issued under agency authority, or a judicial subpoena granted by a court. Each pathway requires adherence to RFPA notice and challenge provisions unless an exception applies. For learners, this layered structure illustrates how privacy rights scale with the seriousness of the process. The law does not shut off government access, but ensures that the means of access are formalized, documented, and subject to checks and balances. This framework reinforces the idea that process is as important as outcome in preserving trust between citizens and government institutions. Search warrants operate somewhat differently under the RFPA. Because warrants are based on probable cause and judicial approval, they permit immediate access to records, but the law still requires delayed customer notice in many circumstances. Agencies may request postponement of notice to avoid jeopardizing investigations, but once the delay expires, customers must be informed. For learners, this provision shows how privacy law balances transparency with investigatory needs. It accepts that some secrecy is necessary in active investigations but insists that secrecy cannot last indefinitely. Eventually, individuals deserve to know that their records were examined, restoring accountability and reinforcing that privacy rights are suspended only temporarily rather than erased altogether. Grand jury subpoenas represent an important carve-out in the RFPA framework. Because of the secrecy surrounding grand jury proceedings, customer notice requirements do not apply. Financial institutions served with such subpoenas must comply without informing the customer, and courts strictly enforce this secrecy. For learners, this highlights the exceptions that temper privacy protections in sensitive legal contexts. While notice is the default in most RFPA scenarios, the integrity of grand jury processes takes precedence. This carve-out illustrates how privacy rights are not absolute but yield to competing interests, in this case the administration of justice, through impartial grand jury proceedings. The RFPA also provides exceptions for authorized investigations, particularly where agencies certify that the records sought are relevant to a legitimate law enforcement inquiry. Agencies must still demonstrate the connection between the records and the investigation, but once certified, the financial institution may be required to comply. For learners, this shows how the law prioritizes relevance as a limiting factor. Investigators cannot demand unlimited archives but must target records that matter to their inquiry. This requirement embodies the principle of minimization, narrowing disclosure to what is necessary rather than exposing broad swaths of financial history without justification. Emergency access provisions allow agencies to bypass normal notice and challenge rules when there is imminent danger of physical injury, serious property damage, or illegal activity requiring immediate action. These provisions are narrowly defined to prevent abuse, but they demonstrate the law's flexibility. For learners, this highlights how privacy statutes incorporate practical exceptions for urgent situations. While due process is the default, emergencies justify temporary departures, reflecting the balance between protecting rights and enabling swift action to prevent harm. Such exceptions remind us that privacy frameworks are not rigid barriers, but adaptable systems that respond to real-world risks. The RFPA applies not only to direct bank records but also to interbank transfer systems and third-party processors that handle payment transactions. Records from services such as check clearinghouses, wire transfer networks, or card processors may all fall under the statute's protections. For learners, this broad scope demonstrates how privacy law adapts to financial infrastructure. Money rarely moves in isolation. It flows through intermediaries and service providers. By extending protections to these channels, the RFPA ensures that privacy safeguards do not collapse simply because transactions pass through third parties. It underscores that confidentiality must follow the data, not remain confined to traditional bank ledgers. Another key principle of the RFPA is specificity. Requests must describe the records sought with reasonable detail, including time ranges and account identifiers, rather than demanding broad categories of information. This prevents phishing expeditions where agencies might otherwise seek everything in a customer's file. For learners, specificity illustrates how precision protects privacy. Narrow requests reduce unnecessary exposure, align with minimization principles, and make it easier for institutions to verify compliance. Vague or sweeping demands are inconsistent with the statute, reinforcing that government access must be deliberate and targeted rather than speculative. Financial institutions also have duties under the RFPA when handling requests. They must verify the legitimacy of the legal process, log all disclosures, and may be entitled to reimbursement for the costs of producing records. These duties reinforce that banks are not passive participants, but active guardians of customer privacy. For learners, this highlights the role of institutions as intermediaries between citizens and the state. By requiring institutions to document and verify every disclosure, the law builds accountability into the process, ensuring that privacy protections are upheld not just in principle, but in daily operations across thousands of requests. Customers retain the ability to challenge RFPA requests in court. They may argue that the request is overly broad, irrelevant, or procedurally defective. Courts can suppress unlawfully obtained records, excluding them from use in legal proceedings. For learners, this safeguard reinforces the accountability loop. Privacy rights are not only aspirational but enforceable. The possibility of suppression ensures that investigators respect the law, while customers gain a meaningful remedy if their rights are violated. This challenge process reflects a core democratic principle. Individuals should not be powerless in the face of government authority, especially when their private financial life is at stake. Confidentiality obligations also apply once records are disclosed. Agencies receiving information under the RFPA may not freely redisclose it to other parties without authorization. These restrictions prevent mission creep, where data provided for one investigation is quietly repurposed for another. For learners, this principle mirrors broader privacy frameworks. Purpose limitation. Information collected for one use must not automatically migrate to others. By restricting redisclosure, the RFPA ensures that compliance with one request does not open the door to unchecked circulation of financial records across government networks. Financial institutions must also align RFPA obligations with their broader privacy programs. This includes reflecting statutory duties in customer privacy notices and embedding compliance obligations into contracts with processors and vendors. For learners, this requirement underscores the interconnectedness of privacy governance. RFPA compliance is not a silo, but part of a larger framework of legal and contractual obligations. By aligning disclosures, contracts, and operational safeguards, organizations demonstrate that financial privacy is a core commitment, not just a narrow response to subpoenas. It becomes part of the institution's identity, reinforcing customer trust in a heavily regulated sector where confidentiality is paramount. For more cyber-related content and books, please check out cyberauthor.me. Also, there are other prepcasts on cybersecurity and more at baremetalcyber.com. The Bank Secrecy Act, or BSA, was enacted in 1970 to combat financial crimes such as money laundering, terrorist financing, and fraud. It requires financial institutions to maintain robust anti-money laundering programs, often referred to as AML programs. These programs are built on four foundational pillars: the establishment of internal controls, the designation of a compliance officer, the implementation of ongoing employee training, and the execution of independent testing to validate program effectiveness. Regulators expect these pillars to form a holistic system that ensures compliance does not depend on a single safeguard but functions as an integrated framework. For learners, this illustrates how governance in financial institutions mirrors cybersecurity or privacy. It requires structured programs, designated leadership, verification mechanisms, and a culture of awareness. The BSA pillars embody the principle that sustainable compliance arises not from one-off actions, but from systems designed for continuous vigilance. A major requirement under the BSA is the Customer Identification Program, or CIP. Financial institutions must verify the identity of individuals opening new accounts, typically by collecting and validating documents such as government-issued identification, social security numbers, or other recognized credentials. This program is rooted in the idea that anonymity in financial systems invites abuse. By requiring institutions to know their customers, regulators aim to prevent criminals from using false identities or shell accounts to move illicit funds. For learners, the CIP demonstrates how financial privacy is not absolute. Customers sacrifice a degree of anonymity to participate in legitimate systems, and in return, the system gains transparency that makes it harder for illegal activity to hide within everyday transactions. It reflects the principle of proportionality. Privacy rights coexist with safeguards that preserve trust in financial markets. Customer due diligence, or CDD, extends the idea of knowing one's customer beyond the initial onboarding step. Institutions must evaluate ongoing risks by understanding the nature of a customer's business, monitoring activity for unusual patterns, and identifying beneficial owners of corporate accounts. The 2016 FinCEN CDD rule clarified that institutions must identify individuals who own or control legal entity customers, often referred to as beneficial ownership. For learners, this requirement underscores how financial systems adapt to evolving risks. Complex ownership structures, shell companies, and international accounts can obscure the true controllers of funds. CDD obligations cut through this opacity, ensuring that financial institutions do not inadvertently facilitate money laundering or the financing of terrorism. It reflects a broader privacy theme. Transparency in critical sectors must outweigh secrecy that could endanger broader society. Currency transaction reports, or CTRs, are another key feature of the BSA framework. Institutions must file CTRs for any transaction involving more than $10,000 in cash in a single day, unless an exemption applies. Reports must be submitted within 15 days, and failure to do so can result in substantial penalties. While some argue that the threshold captures legitimate activity, regulators emphasize that CTRs create a paper trail that helps investigators identify suspicious patterns. For learners, CTRs illustrate how privacy yields to accountability in high-risk contexts. Cash transactions offer anonymity, but reporting ensures that large movements of physical currency do not escape oversight. These reports demonstrate the trade-off between individual freedom in handling cash and society's need to guard against financial crimes that thrive on untraceable transactions. Suspicious Activity Reports, or SARs, represent perhaps the most powerful and sensitive disclosure obligation under the BSA. Institutions must file a SAR whenever they detect activity that appears suspicious, whether or not it meets specific monetary thresholds. Examples include structuring transactions to avoid reporting limits, unusual wire transfers, or patterns inconsistent with a customer's profile. SARs must include detailed narratives explaining the suspicion, and most importantly, they are subject to strict confidentiality rules. Institutions cannot disclose to customers that a SAR has been filed, a concept known as the prohibition on tipping off. For learners, SARs embody the balance between trust and secrecy. Customers expect confidentiality, but when transactions raise red flags, institutions are legally required to report. The secrecy protects investigations, but also challenges institutions to maintain customer relationships without revealing hidden compliance obligations. Section 314 of the USA Patriot Act added new information sharing mechanisms to strengthen the BSA framework. Section 314A allows regulators to circulate lists of persons under investigation and requires institutions to search their records for connections, while Section 314B permits voluntary information sharing among institutions to identify suspicious activity. Together, these provisions encourage collaboration across the financial sector while providing liability protections for sharing information in good faith. For learners, this highlights the concept of collective defense in privacy and compliance. Just as cybersecurity thrives on shared threat intelligence, financial systems rely on shared awareness of risks. The challenge lies in balancing collaboration with privacy, ensuring that shared information is relevant, limited, and protected from misuse, even while enhancing the sector's ability to combat systemic threats. The travel rule is another BSA obligation, requiring institutions to include certain originator and beneficiary information when transferring funds over $3,000. This rule ensures that critical identifying details accompany the transaction as it moves through the financial system, preventing anonymity in cross-border and domestic transfers. For learners, the travel rule illustrates how privacy is intentionally constrained to enable traceability. Much like labeling parcels with sender and recipient information, financial transfers carry metadata that provides accountability and aids investigations. The travel rule demonstrates how transparency requirements extend beyond the institution's boundaries, embedding privacy trade-offs into the fabric of global transaction networks. Effective anti-money laundering programs also depend on model risk management and monitoring calibration. Institutions use automated systems to scan transactions for anomalies, but poorly calibrated models can generate overwhelming false positives or miss critical red flags. Regulators expect institutions to review and validate their monitoring tools regularly, ensuring they are neither perfunctory nor excessively burdensome. For learners, this illustrates the intersection of technology and privacy. Automated surveillance of transactions carries risks of overcollection or unnecessary intrusion, but without careful calibration, financial crime can slip through unnoticed. Responsible monitoring reflects a balance between protecting privacy and safeguarding the integrity of the financial system, emphasizing precision and accountability in the use of automated tools. The BSA also sets specific retention requirements, obligating institutions to keep certain account and transaction records for at least 5 years. This retention period ensures investigators can trace activity long after the transaction occurred. For learners, this demonstrates the privacy trade-offs inherent in compliance. Longer retention supports accountability but increases risks of data exposure if systems are breached. Institutions must therefore manage retention with strong security measures, treating stored records as sensitive assets rather than passive archives. The retention requirement reinforces the principle that compliance obligations persist long after a transaction, intertwining data governance, security, and privacy into a continuous lifecycle. Sanctions compliance, particularly through alignment with the Office of Foreign Assets Control, or OFAC, integrates with BSA obligations. Institutions must screen customers and transactions against OFAC lists to prevent dealings with sanctioned individuals, organizations, or countries. These screenings add another dimension of monitoring that overlaps with BSA reporting. For learners, OFAC demonstrates how privacy intersects with geopolitics. Customers may expect confidentiality, but if they are linked to sanctioned entities, institutions must act to block or report activity. This intersection shows how privacy rights are balanced not only against domestic crime prevention, but also against broader national security and foreign policy objectives. Examiners and regulators play a central role in ensuring BSA compliance. During audits, they expect institutions to demonstrate effective programs, conduct look-back reviews when weaknesses are found, and remediate gaps promptly. Findings may require institutions to revisit years of records, uncovering previously missed suspicious activity. For learners, this illustrates the accountability loop built into compliance frameworks. BSA obligations are not static. They require continuous improvement and adaptation to regulatory expectations. Institutions that fall short face enforcement actions, fines, and reputational damage. This underscores how financial privacy obligations must be embedded into governance at all levels, from board oversight to frontline monitoring. SAR confidentiality creates challenges when law enforcement requests overlap with BSA reporting duties. Institutions cannot disclose whether a SAR has been filed, even to the subject of the investigation, but they must cooperate with investigators in related matters. For learners, this tension illustrates the delicate balancing act of confidentiality. Institutions must protect the secrecy of their regulatory filings while still honoring legal demands, often requiring close coordination with regulators and counsel. This highlights the complexity of privacy obligations in heavily regulated sectors, where duties to different authorities may conflict, and careful navigation is required to maintain compliance across overlapping frameworks. Cross-border correspondent banking adds another layer of risk. Institutions that maintain accounts for foreign banks must perform enhanced due diligence, ensuring that their partners are not being used as conduits for illicit finance. This requires greater transparency into ownership, operations, and risk management practices of foreign correspondents. For learners, correspondent banking illustrates how privacy is reshaped by globalization. Information must flow across borders to mitigate systemic risks, but it must do so under frameworks that respect confidentiality and proportionality. Enhanced due diligence reflects the recognition that international cooperation is essential, but it also demonstrates how compliance expectations increase as risks rise in cross-border contexts. Board-level reporting is essential to sustaining AML compliance. Regulators expect institutions to provide senior leadership with metrics on suspicious activity, regulatory findings, and remediation progress. This ensures that compliance is not siloed in back-office operations but treated as a strategic priority. For learners, board reporting underscores the governance dimension of financial privacy. Just as cybersecurity requires executive buy-in, BSA compliance depends on leadership engagement. Metrics transform abstract obligations into tangible measures, driving accountability from the top down and embedding compliance into the institution's culture. Without board-level attention, programs risk becoming reactive and underfunded, leaving institutions vulnerable to both regulatory penalties and reputational harm. In conclusion, the Bank Secrecy Act reshaped financial privacy by creating mandatory disclosure obligations that coexist uneasily with customer confidentiality. Its pillars, reporting mechanisms, and monitoring requirements reflect the principle that financial privacy cannot be absolute in a system vulnerable to crime and abuse. For learners, the synthesis of RFPA and BSA highlights the dual nature of financial privacy law. One statute protects individuals through notice and due process, while the other mandates proactive surveillance to defend against systemic risks. Together, they illustrate how privacy in financial systems is always a balance between individual rights and collective security, between confidentiality and transparency, and between minimizing data use and preserving accountability for the long term. Thanks for tuning in to the Bare Metal Cyber Prepcast, your trusted source for cybersecurity news and insights. Remember to subscribe at baremetalcyber.com so you never miss an update. And visit cyberauthor.me for best-selling cybersecurity books that equip you with expert knowledge. Until next time, stay secure and stay vigilant.